Let's bring in legal analyst Alton Hart to unpack the impeachment hearing of the suspended public protector Busisiwe Mkhwebane. A very good afternoon to you, Alton. Thank you for your time here on the SABC.
Good afternoon, Liesl, and good afternoon to your viewers.
On the back of the clip from the suspended public protector, perhaps you could help us understand the dynamics unfolding here. Can the hearing, in fact, continue without legal representation for Mkhwebane? Will her right to legal representation not be violated if the inquiry continued with its work?
Liesl, I can put it in simple words for the South Africans out there. I think Janji thinks that he's a judge now, that he can just disregard a constitutional court ruling where he would proceed or allow the committee sitting to proceed without the person that is discussed and implicated in these proceedings not being there. The audi alteram partem rule, which says you need to hear both sides of the story, is not adhered to. So yeah, this whole process from where it started when she's not there up until now, whatever has happened is flawed. And she can easily take it on review to court. So for me, what they are doing now there is exactly like Busisiwe Mkhwebane is alleging, that they are now trying to actually sort of have fill the minds of MPs with a one-sided affair, and which is not fair. So her rights are being violated, and I'm not taking her side. I'm just seeing what I'm seeing here. He's not supposed, the moment they said there's no funding and the funding is withdrawn, they should immediately stop the proceedings and sort out the funding issue. Until that funding is not secured and sorted out, they cannot proceed, because she has the right to a fair trial. That's granted and guaranteed in our constitution.
Metsi continued to hear an analysis of evidence from evidence leaders on Tuesday, despite Mkhwebane's objections. What are the implications? What is the implications on the credibility of its findings as it continues in this manner?
No, obviously for me, where they now, it's like in a trial, if you're in a court of law, you'll have the evidence first, like from one side, and then the evidence from the other side. So once the evidence of both parties has been presented, there was cross-examination, re-examination, and it's now a close of the leading of evidence. Witness leading has been done. Then you would go into what we call heads of argument, where you summarize your evidence and now put your arguments forth. Now what I'm currently seeing as we are talking here, currently what's happening in that committee, it looks like the evidence leader is already summarizing her evidence that she led without having heard the full story from the suspended public protector, and also giving her side of what each of these events would symbolize, so that the MPs then have a balanced view from two sides to say, now we can actually adhere to the audi alteram partem rule, which says we have to hear and weigh up both sides of the story. So for me, what I'm seeing here, this is it's an injustice. It's a travesty of justice that's actually happening here to this suspended public protector. And this is not me favoring her. This is me just from a legal perspective, and this is not what I want law students to see. This is how things are done in our parliament, which is supposed to be our protector of our constitution.
Alton, then on the back of that, we heard from the suspended public protector, labeling the committee meeting, as a backdoor inquiry disguised as a meeting. So at this stage, what actions can be taken by the suspended public protector? She has threatened to take further action as the Section 194 committee continues to dive into evidence without her lawyers present.
Now, obviously, what she can do is, like, she can approach the Western Cape High Court on an urgent basis to say that they interdict the further proceedings in this committee, so that they interdict, that they stop everything in this committee, and in a part B to say that they first need to then say, we stop the meeting until my funding is sorted out. Only when the funding is sorted out that we can then now go on to actually have my legal representations there. Because also, if one looks at it now, even if she gets different legal representatives, they have to go through all the committee records, all the evidence that was presented already. So that will take another couple of days to actually sort out. And also the cost, the wasted cost that will go into there. So it's not fair on the taxpayer. So if the chairperson of this committee is even remotely woke to what the constitutional values is, and also how it will affect the public purse, then you will say, let me rather just stop here, pause, because this might just lead to a lot of things that should and could have been avoided. Because she can take this report on, if they make a finding, she can take it on review, and then the court will say, but you guys was wrong. everything has to start, then it's a whole waste of taxpayers' money. So, but interdicting the proceedings, I think that is her lawyers, she can now approach lawyers to say, interdict these proceedings, to stop right where it is and disregard everything that was done without me being present. And I already think what this Section 194 committee meeting is now already, one should not even look at it. I don't think it's fair at this point in time, because the information is already told to the MPs. So they have it in their minds. Even if you say wipe it out by a court order, it still sits in the minds of these MPs. So I think this proceedings is no longer fair.
On Monday, the lack of funding for the suspended public protector's legal team was dominated proceedings. And you've now spoken about the costs incurred, but also the costs incurred to date and what that means for the ordinary taxpayers as well. But so I want to look at the implications, because ultimately there's a report that has to be delivered. And according to the revised program, the committee aims to complete its work by the end of May, including adopting this final report on the inquiry. Is that likely? And when we look at, the implications that this matter is going to have in other Chapter 9 institutions, what precedence is being set?
It's absolutely total bad precedent. And for them to actually now push the whole process ripe is also not right, because as the Constitutional Court said, when they said, okay, here's the committee, you need to subject, based on the findings of the three panel that said there is grounds and there's things that before the suspended public protector needs to answer, they said she's entitled to legal representation. Now, there's already cost that was put into this process. Now, to actually say to her, listen, you need to proceed on your own, or whatever's going to happen, there will be wasted costs. That they will never get this done at the end of May, because she's in the middle of her testimony. Now, that is unlikely that you can stop a person that is representing, that is making representations in the middle, and then say, okay, we'll make a finding, but you have not even made your representations. That in itself, it's reviewable by any court. I don't see how this committee will get past it. The only way that the committee will be able to adopt this is when the ANC will use the outright majority in that committee to say, we're not going to now apply our minds and apply the principles in the Constitution. We're just going to say majority because we want to get rid of Busisiwe Mkhwebane because she's not good for the ANC at this point in time. And that's what they can do. Because we already saw that other opposition MPs was not in favor of them proceeding without her having her legal representation. So this will have just a lot of bad adverse implications for this committee to continue and to actually complete the work, and then for that report to stand the test of time when it's taken on review to court, because it will be taken on review. That I can guarantee you.
Thank you for your time here on the SABC. Legal analyst Alton Hart unpacking the impeachment hearing of the suspended public protector Busisiwe Mkhwebane. We saw on Monday the lack of funding for Mkhwebane's legal team having dominated proceedings at the inquiry. Again, a story we'll continue to monitor, perhaps also the implications from here into for both her, the team, and Chapter 9 institutions in South Africa at large.